On March 2, 2022, Rogue Nation began filming the Gulfport, Mississippi Probation Office in Gulfport, Mississippi. The following footage is from his channel.
Let me get some information on the windows out here. It says trial calendar. This might be part of like a court annex type deal. The lady said she was gonna find out where the probation office was around here. I could have swore GPS put us right here.
Can I help you, sir?
I was looking for the probation office.
Okay. How can I help you?
Do you know where it's at?
This is it.
Oh, okay. Yeah, I just wanted to go in the lobby and look at what's available for the public.
You can't go in the lobby.
Why not?
Because I said you can't go in the lobby.
Oh, you're above the Supreme Court?
The Supreme Court. We have a COVID right now.
What
do you need? What do you need in the lobby?
I just want to see what's available for the public. Any kind of public information, that kind of stuff.
All right. Go ahead and read and sign this.
Go,
All right, read and sign that. Read and sign this. Name, date, and then all these questions as it applies to you. If you're over 27, over
That's a
27,
beautiful place to go have lunch.
all right? Read that. Initial that out. Same thing here. All these questions that it applies to you. All right? Once you finish, you can stop right there and just knock on the door and come out. All right?
Yes, sir. Thank you, man.
Where do you live?
Louisiana. That was gonna be one of my next questions. Yes, sir. That was
You
gonna be
would've
one of my
started with
next.
that.
Well, that was gonna be one of my next questions. How do I go about switching, or if it's even needed to be switched? Because
Okay,
I'm
the
more
person-
than willing to.
Yes, we have one officer that handles the ICOTs.
Yes, sir.
She is not here. Okay, so can you come back or are you going straight?
I'm going straight back to Louisiana. I've got work to do.
We can come back another day.
Okay, do me a favor. Start on this. Let me see if I can get in touch with you.
Thank you, man.
All right,
I
no problem.
appreciate it.
Thank you, sir.
Yes, sir.
Are we good to go here, sir?
As rude as this employee appears to be, it would be difficult to conclude that Rogue Nation had a First Amendment right to enter the building. In Press Enterprise versus Superior Court of California, the U.S. Supreme Court laid forth a two-pronged test for determining if a member of the public has a qualified right to access a piece of public property. First, the public must have had a historical right of access to the place at issue, and second, public access must play a significant positive role in the function thereof. When dealing with claims of public access, particularly those dealing with speech-related activity, it is necessary to view the claim in light of the type of forum the place is. As the Supreme Court said in Cornelius versus NAACP Legal Defense Education Fund, the extent to which the government can control access depends on the nature of the relevant forum. The public forum test has its roots in the 1939 case of Hague versus Committee for Industrial Organization, which held that banning assemblies in public streets and parks violated the First Amendment's freedom of assembly. In reaching this conclusion, Justice Owen Roberts said, "Wherever the title of streets and parks may rest, they have immemorially been held in trust for the use of the public and, time out of mind, have been used for purposes of assembly, communicating thoughts between citizens, and discussing public questions. Such use of the streets and public places has, from ancient times, been a part of the privileges, immunities, rights, and liberties of citizens." Since this case, the public forum test has been found to be essential in determining the validity of free speech, assembly, press, and access claims. In Perry Education Association versus Perry Local Educators Association, the court identified three types of forums: traditional public forums, designated public forums, and non-public forums. Traditional public forums include public property that has been traditionally open to the public for access, speech, and discourse, such as public parks and sidewalks. Designated public forums include property that is not historically open for public access, speech, and discourse, but that the government has opened up for that purpose. Non-public forums include all other public property that generally exists for purposes other than public access, speech, and discourse. The probation office would fall into the third category. Probation offices have always been established for the purpose of training probation officers and rehabilitating convicted offenders, not for engaging in public discourse, and this office has clearly not been opened up for that purpose. Therefore, the office would be viewed as a non-public forum. As a non-public forum, the regulation on speech and access to the property must be reasonable in light of the purpose of the forum, and it must be viewpoint neutral. Since Rogue Nation's presence and filming did not have any relation to the purpose of the probation office and there is no evidence of viewpoint bias, his exclusion almost certainly would be found to be constitutional.
Yeah, I guess not.
I like your first class too.
Thank you.
I do, I really do.
Yeah. I wish they did.
Oh, I like that. Oh, that's good, that's good.
Yeah, it gets a chuckle here and there.
I like that. I do. I really do.
I don't need it, honey, thank you. That was very nice of you, though, thank you.
You say you don't or you do?
Yeah, I'll be leaving in a few minutes, thank you. I don't need any help, though.
Why are you recording us, sir? Can I help you?
I don't need any help, thank you. You can go back to work. There you go.
How you doing, sir? Sir.
What can I help you with, sir? Lieutenant
Yes.
Bradley
Yeah.
Walker,
Yes.
6011.
We got a phone call about you videotaping the employees here.
Sweet. Jefferson. I can't see your badge number.
That's actually my employee number. Badge number is 178.
Oh, thank you. Yeah, gentlemen. Yeah, it's not illegal. They're good. Thank you.
Okay, do you have some ID, sir?
For what?
Because it's standard protocol. Anytime we get a call on someone, we come out here and identify them.
It's standard protocol,
Yes.
so it's standard protocol to violate the Fourth Amendment.
I'm not violating your Fourth Amendment, sir. I'm not
Do you
doing
suspect me of a crime?
We got a reasonable suspicion because you were called upon.
So a call gives you a reasonable suspicion, though?
Yes.
What case is that?
Sir, do you have identification on you?
No, I don't. I don't carry identification on me because I don't break the law. And the law is only required if you suspect me of committing, have committed, or about to commit a crime. Getting a call is not reasonable suspicion. Brown v. Texas.
In Brown versus Texas, the U.S. Supreme Court said that officers did not have reasonable suspicion that a man was engaged in illegal activity simply because he was in a place that happened to be used by criminals for illegal activity, and without that suspicion, they could not force him to identify himself. The officers in this video claim that, unlike the officers in that case, they had reasonable suspicion because of the call they received alleging that he was filming the employees. While a 911 call can constitute reasonable suspicion in some circumstances, in the case of Florida versus J.L., the U.S. Supreme Court ruled that a caller must give enough information to express some knowledge of potential illegal activity to be reliable. Similarly, while the First Amendment itself may not have protected Rogue Nation's decision to film on the property, there is no state or local law that prohibits that conduct. Therefore, unless the caller reported that Rogue Nation was trespassing, the officers likely lacked the reasonable suspicion necessary to detain him, and therefore could not constitutionally identify him. But even if they could, there is no state or local law requiring him to identify himself, meaning they could not force him to do so even if it would be otherwise permissible under the Fourth Amendment. That being said, the officers did not identify him, and probably did not seize him in the first place. As the U.S. Supreme Court said in the case of Florida versus Bostick, our cases make it clear that a seizure does not occur simply because a police officer approaches an individual and asks a few questions. So long as a reasonable person would feel free to disregard the police and go about his business, the encounter is consensual, and no reasonable suspicion is required. The encounter will not trigger Fourth Amendment scrutiny unless it loses its consensual nature. While there were a couple officers here, the fact that they approached him and asked him for his identification would not itself constitute a seizure. Therefore, the officers did not violate the Fourth Amendment.
Can you reach out to the complainant and find out?
Absolutely was. This property right here, it's all public property. That's why it says Harrison County right there on the front.
Gotcha. Any particular reason why you want to videotape?
Because it's all right. Because I'm a citizen journalist and I go around looking to make sure that the government is doing what they should be, not having their hands in the till, that kind of stuff. So, yeah, it's perfectly legal. I do it all over the country. Brandsburg v. Hague, Supreme Court says I'm allowed anywhere that the public's allowed to be. No restricted access signs, no trespassing signs. Harrison County, it's obviously public property. Yeah.
Just like going around videotaping public property.
I don't like it, but it's my civic duty. It's all of our civic's duty to watch the government to make sure they're doing the right thing.
We are probably some of the biggest supporters of people's rights.
Okay.
That they are.
Well, yeah, I love it. Like I said, I've been doing this 3 years, over 1,000 videos, 10 states, so I know exactly what the law is. I know.
Have you done some here before?
Hattiesburg and Jackson. I haven't been down south here yet. This is my first time coming through. But I have been to Hattiesburg and Jackson, Mississippi.
I got you.
But I've done all of Alabama, all of Georgia, all of Florida, most of South Carolina, LA, Chicago, New York, DC,
We got a call on you. Come out here that you're videotaping.
Yeah.
A lot of these state employees, they do not want to be videotaped. And they have that right. They have that right, yes.
Because I can quote like 10 cases that say they
don't.
don't.
If there's anything inside there that says no video cameras or anything like
Oh,
that.
I never went inside.
Okay.
So I was outside the whole time, but just a couple right off the top of my head. Smith v. Cumming, 11th Circuit, right to videotape public officials in the course of their duties. Iabuchi versus Boulder, 1st District, right to record public officials in a public building having a private conversation. I mean, it's all out there. Yeah, these guys,
Again.
anybody in public, as you know, has no expectation of privacy, including state workers.
In the case of Turner versus Driver, the U.S. Court of Appeals for the Fifth Circuit, which presides over this state, said, First Amendment principles, controlling authority, and persuasive precedent demonstrate that a First Amendment right to record the police does exist, subject only to reasonable time, place, and manner restrictions. However, Rogue Nation's reliance on these cases is misplaced. Smith versus City of Cumming used the same wording as the Fifth Circuit eventually used in Turner and held that the right to film police was only subject to reasonable time, place, and manner restrictions. In traditional and designated public forums, restrictions on speech are subject to two forms of scrutiny. Content-based speech restrictions, which dictate the topic or content of one's message, are subject to strict scrutiny. This means the restriction must be necessary to advance a compelling government interest and be narrowly tailored to meet that interest. Content-neutral restrictions are restrictions that are imposed without regard to the content of one's speech. A blanket ban on access or filming in or from a certain area, like in this video, is a content-neutral regulation. These are referred to as time, place, and manner restrictions, and in order for them to be reasonable, they are subject to intermediate scrutiny. This means the restriction must be significantly related to a substantial government interest, must be narrowly tailored to meet this interest, and must leave open other means of communication. However, the area he was filming is a non-public forum. In United States Postal Service versus Greenburgh Civic Associations, the Supreme Court held that speech restrictions on non-public forums, such as the one here, do not need to be subjected to a time, place, and manner analysis to be constitutional. Instead, they must only be reasonable and viewpoint neutral. As the 11th Circuit, which originally decided Smith, said in the case of Crocker versus Beatty, Smith's reference to reasonable time, manner, and place restrictions calls to mind either a traditional public forum or a designated public forum. Smith's allusion to these restrictions indicates that the plaintiffs there attempted to film police activity while in a public forum of some sort. Smith would seem to be a First Amendment anomaly otherwise. In a footnote they clarified, given that Smith said that the only possible restrictions on the right that it recognized were time, place, and manner restrictions, one can reasonably infer that the court there recognized a right to record police conduct in public forums. Given that this is a non-public forum, Smith would not apply. And since the Fifth Circuit used the same language as Smith in Turner, they would probably conclude that Turner does not apply. Given the nature of the forum and the case law at issue, Rogue Nation would almost certainly be found to lack the right to access and film on the property. As the U.S. District Court for the District of Colorado said in the case of Kerr versus City of Boulder, after finding certain jail property to be a non-public forum, the court finds that plaintiffs did not have a First Amendment constitutional right to film while on jail property. None of these cases or any other case cited by plaintiffs holds that they had a clearly established right to be on jail, or similar, property and film at will. Plaintiffs did not have a constitutionally protected right to film on jail property. It should be noted that this case used Smith and Turner to come to its conclusion.
So, I mean, yes, I totally agree with you.
Yeah, because you guys run tags all the time without
you have to
brass.
respect people, especially that are driving their private vehicle, that, you know, there's people out there that figure out ways, and if you're posting that on there, then that infringes on their private life instead of their public life.
Yeah, you know, and that's a good point. That's a great point. But
so, again,
we don't live our lives on what ifs.
Yeah.
Because that same guy that looks at my video, he could drive by and look at the license plate himself.
Yeah, exactly.
But we don't do what ifs.
How many people view your videos around the country?
It's around the world, but not a lot. 50,
So
75,000.
again, though, by doing that, just think of some of the, you know, you might not view it as consequences, but potential consequences that, again, you could be held civilly liable because of that. So all I'm saying is, you know, we're not going to give you any grief about you doing your constitutional right, but keep that in mind as well to respect other people.
Oh yeah, I always do. Like I say, I follow the law as long as it's lawful. I have some morals. I don't go chasing ambulances or sticking my, you know, cameras in victims' faces and stuff like that.
Yeah.
But I mean, the whole point of me being out here is to teach people about their rights. So I can't teach people about the rights if I'm not exercising them to the fullest and how they should be exercised.
I understand, sir.
Yeah, so that's all I'm doing. I don't cause confrontation. I'm not looking for confrontation. So, you know.
What's your name?
My name's George.
George.
Yep.
Bradley Walker.
But I go by Majorly Awesome.
I hear you.
Yep.
Eventually, everyone went on their way. Overall, the original employees get an F. While they likely did not violate the First Amendment, they were unnecessarily rude to a member of the public. As public servants, their first priority should be to please the people, not to be aggressive toward them. They clearly portrayed an unprofessional demeanor and even called the police on him for seemingly no reason. They should not be public officials if they can't seem to be respectful to the public. The police officers get a C-. While they did not actually violate the Fourth Amendment and held a calm and friendly demeanor, their entire understanding of cause and reasonable suspicion under the Fourth Amendment is contrary to even basic constitutional law, and they appeared to not even understand their state's lack of a stop and identify law. These are basic and essential rules to being a police officer, and if the officers in this case don't know them, they should step back and retake a Constitution course. Rogue Nation also gets a C-. He did not understand the public forum doctrine, misapplied the cases he cited, and, like the officers, appeared to be mistaken on some of the principles of the Fourth Amendment. He also attempted to use Brown v. Texas in support of his argument that a call does not furnish reasonable suspicion, even though that is not true in all circumstances, and Brown v. Texas did not deal with a 911 call. Further, he did not know about the state's lack of a stop and identify law. As stated previously, one's knowledge and application of the law is essential in these cases, and unfortunately that knowledge and application was quite slim here.